Well, good afternoon, everyone. How's the mic working today? Yeah, it sounds good. All right. Well, welcome to today's edition of Northeastern at Noon. Glad to see everyone here. How many of you have participated in a trial in some fashion, either as a witness or a juror member or even a spectator? Many of you. How many of you have engaged a lawyer for whatever reason? Many of you again. Well, that's very fortunate, because what it means is that all of you have actual personal life experiences that you can use to compare with how trials and lawyers are presented in the entertainment media. One last question. How many of you can identify a famous TV lawyer who would quite often, in fact almost every episode, say something like this: "Objection, Your Honor, that question is irrelevant, incompetent, and immaterial." And quite often that would be followed by, "It calls for facts not yet in evidence." And that would quite often be followed by, "Your point is well taken." Well, if you're guessing that that was Raymond Burr as Perry Mason, then it means either you have very good memories, or you're like me and you stay up too late watching old-time reruns. But while Perry Mason may be one of the more identifiable lawyer trial series, we're very pleased to have with us today someone who will acquaint us with the many others, equally, if not in their time, more popular. And that speaker is Professor Jessica Silbey. She's a professor of law here at Northeastern's School of Law, where she teaches in the areas of intellectual property and constitutional rights. Her research specialty focuses on various aspects of the legal regulation of creative and innovative work. She both writes and researches in the field of law and film, exploring how film is used as a legal tool and how it becomes an object of legal analysis. In addition, she considers the use of film as a tool, things such as body cams, surveillance videos, even medical imaging. She also considers the representation of law in popular culture, things such as courtroom dramas and reality television. Her most recent book, considered a groundbreaker, is The Eureka Myth: Creators, Innovators, and Everyday Intellectual Property. That was published by Stanford University Press just last year. Her previous book was entitled Law and Justice on the Small Screen, and that was co-edited with Peter Robson. Over the years, as you might expect, she's written many articles in law reviews and a variety of other publications. She earned her Bachelor of Arts with honors and her JD cum laude from Stanford University, and went on to receive a PhD in comparative literature from Michigan. Sorry, but I'm a Ohio State fan. Prior to teaching, she clerked in the federal courts and worked in private practice, focusing on intellectual property and reproductive rights. Finally, I'd like to note that she's been invited to speak about her research at the nation's leading law schools, schools such as Harvard, New York University, and Yale. And in addition to that, she's been invited to speak at universities in Canada, England, Australia, and Germany. Now, I could go on, but I think it's high time we call our first witness, who is an acknowledged expert, and we'll stipulate to that. So, will Professor Selby please take the stand?
What an introduction. Okay, if you can't hear me, just raise your hand if at any point you can't hear me. So I'm really pleased to be here. I think the test of whether my CV stands up is whether I can keep you interested for about 35 minutes or so while showing pictures of various film stills over the past 100 years. So as Joe said, one of my personal obsessions is the relationship of film and law. And I got into this area while I was pursuing a PhD in comparative literature and film, while at the same time going to law school, studying about the intersection of popular culture and law. I was, and continue to be today, very interested in questions of how popular consciousness, including popular legal consciousness, are shaped by art form, such as film. So the fact of the shaping, I think, should be pretty obvious to us all. We say that, or I say anyway, to my children all the time, too much television or video games are bad for you. And then you have to like, why? Why is it bad? Well, because in the main, if you think about what those images are, either on video games or television, in the main, it will teach you to desire fast food, probably more than like your vegetables. I have 2 girls, to be beautiful instead of kind and curious, to consume rather than to make, to hold weapons rather than to build robots. I could go on. Not all popular culture is negative, of course, and neither is it homogeneous. As such, it successfully constitutes communities, diverse communities of people and thought. All forms of popular culture, television, music, film, help form us as a people and a community insofar as we are consumers and admirers of that culture. So I started wondering when I was a graduate student, what kind of community does our legal popular culture constitute? If we were to look at the mainstream films and television shows about law, what do they tell us about how law is or should be in our society? How do they help structure our expectations about the American justice system? So I should say, as a first-year law professor, I teach in the upper division too, but I have students who come like first day of law school, and they come with these expectations of what law is. And I spend a lot of time disabusing them of Perry Mason, or the 21st century of Perry Mason. So what we're going to talk about is what those images are. So I'm going to explore this question with you. I'm going to trace a history of law in film, in particular the history of the trial film, the courtroom drama, from cinema's inception in 1894 to the present. So what I hope will be interesting about this film history is not only that it's a story about law films, but it's also about how film as a medium communicates and builds communities, sharing certain preoccupations with law as a system of justice. So you'll see that film as a medium of communication and culture is particularly well suited to tell stories about law. I will show that how even in the earliest days of film, it was preoccupied with what it means to know things through the visual sight, to the visual sense, with the relationship between being a witness and judging a situation. So these preoccupations, which are themes in the early trial films, are questions that are both filmic, about how film means through sight, and legal. And they were embedded and shaped theories of film from the very beginning. So at the end of the presentation, I'll ask some of these questions about film and law today. In police cars, for example, in courtrooms, and how the history of film might shed some light on what we should be doing with film as lawyers and judges and citizens that desire equal justice under the law. So let me start with a couple definitions. So when I talk about law, I'm not only or necessarily talking about statutes or cases or constitutions. Really, I'm not talking about technical law on the books at all. When I'm talking about law, I'm talking about its popular incarnation. That is really sort of the trial, as you said, calling me to the stand, because trials are that ubiquitous symbol of law and justice in our popular culture. The trial is, in fact, particularly well suited to film because the courtroom genre, that trial genre, shares with the more general strategies of filmmaking and law process the authority of its story that's grounded in each individual person who claims to know and judge the world based on our capacity to observe and deliberate. So when I talk about film, I'm not only talking about what the film or video says, that is only its story, but I'm also thinking about how it says what it says, its distinct way of making meaning as this visual phenomenon whose significance comes from, I would say, an overdetermined and illusory conflation of the images on screen with the event being filmed. The film constructs this community through acts of visual display, manufacturing a coherence so that when we see something on screen, we experience it as if it were part of our world here and now, a conflation of seeing with witnessing. So the history I'm going to tell you will be visual, and it'll be largely on the screen behind me. And so it's a history of film and law in pictures. So let's go back to 1894. So these are the Lumiere brothers. The Lumiere brothers were fascinated with Thomas Edison's kinetoscope. Auguste and Louis Lumiere in France developed the first moving picture machine. And a year later, in 1895, in the Grand Café in Paris, they set up the first movie theater. They showed 4 films that night, but the first film they showed was this film called L'arrivée en train en guerre, which is the arrival of a train in a station. And the story goes that upon the showing of this particular film, which was of a train, this is only a 15-second film, a train arriving into a station, and as the train got closer and closer into the station, it got bigger and bigger on the screen because the camera was set up on the quay. The audience members stood up and screamed, thinking that the train was going to run them down. They ran out of the theater, and they never saw the end of the film. So the notion that film had a particularly real feel, enabling the audience to bear witness to some event projected on screen, began there. In 1902, the film genre was already changing from these old actuality, sort of mini documentaries, to narrative and fantasy. So this is Georges Méliès's film from 1902 called A Trip to the Moon. And his films looked like stage plays. This is very hard to see, I realize. I apologize. But it's really just a stage with a sequence of events. And the camera would be passive as people would run on and off the stage, and puppeteers moved props. But his films told a much more complex narrative story, the way theater did, not an actuality film like of a train arriving into a station. And in so doing, it evolved the audience in the story in a new way. So his film called The Magic Lantern, which is the first film that is about film. So this is 1903, and already film is telling stories about itself as a way of telling stories. And it was a film about Western dramatic art. So it showed first a landscape painting and people hanging around that, and then a play in a theater, and then the image of this newly developed moving picture. And it placed film in the trajectory of Western representational art, suggesting that film art is no more or less faithful to its subject than a painting or a play. But it also piques the spectator's attention, drawing the audience out of its story and passive watching into a more critical role of contributing to and critiquing the story in the film. So we were made as audience members to recognize that the film story is just one representational scheme among others, and that we as audience members making that connection between painting and theater and film were perpetuating that story. So self-reflexivity in film, calling attention to film's own artifice and relying on the audience to do so, was the beginning of audience participation that films told. It's, for example, how you might think how audience members might experience film as jurors that experience trials. We're isolated and apart when we sit in the jury bench, the way we are isolated and apart when we sit in the film theater. But we are acutely aware that our role as spectators or as judges is the reason the film and the trial is happening in the first place. There's another film that's happening at this time that's critical, and that's Edwin Porter's Great Train Robbery. I don't know how many people know this film. It was also made in 1903, but it was made in the United States. And this film was credited as the first pseudo-documentary. So when I say pseudo, so the Lumiere brothers' actuality film, that was a real documentary. That was the train coming into the station. But Edwin Porter's Great Train Robbery was a pseudo-documentary because it was a story about a train robbery, a fake train robbery. But there was fear that came around this film that it was going to teach people how to rob a train. And there was all this debate about whether to censor it because of the emphatic and powerful role that film plays. Film is a very effective teaching tool and telling us the truth about how life might be, or at least persuading us. Now, its other contribution to film in 1903 was its editing structure. So film juxtaposes shots of otherwise discontinuous images, creating connections between those images that might not be there before. So let me give you an example. This is a set of images that were part of what's called the Kuleshov Experiment, done in Moscow and brought into the United States. You see on the right a single shot of a man holding his chin. It's the same shot all the way down. And on the left, you see a bowl of food, a corpse, and a half-naked woman in bed. Now, the experiment showed that the expression on the man's face was interpreted differently depending on the shot that preceded it. So, food, face, he's hungry. Corpse, face, he's mourning. Half-naked woman, face, he's lustful. So the experimentally established that the meaning from the film, when these two shots are put together, don't come from the images themselves, they come from the audience's interpretation of the images together. So this is the beginning of how the audience brings the story to the images. We participate in the story that is being told. This is called montage in film theory, and we do it all the time in our everyday life. It is the way we make sense through narrative. D.W. Griffith was a great filmmaker during this time, and he manipulated montage in a way that became very, very artful. So one of his contributions to film, in addition to montage, was the close-up, intimacy, when the camera gets really close. Also deep focus. So being able to have focus both far away in the shot and very close, which gives you a sense of omniscience. So the camera's structure and the frame has different senses of persuasion. Intimacy, we feel intimate, and we feel omniscient in these. He also, as a filmmaker, made one of the first trial films. It was in 1907, and it's called Falsely Accused. So this is 1907. This is a little more than 10 years after film was born. We have our first trial film. So Falsely Accused opens with the story of a murder of an inventor and the false accusation that his daughter committed the crime. The daughter's boyfriend is dwelling on the crime scene and, finds a motion picture camera miraculously running during the commission of the crime. And let's just pause to think. This is 1907. Film is only about 10 years old. Now we have a film about law where the hidden evidence is captured on film, right? This was fun as a graduate student to think deeply about this, right? Okay, so what does he do? He grabs the camera and he rushes to court. They put up a screen in court. This is the picture of the screen in court. And they're going to reveal the true murderer that was caught on the film, the missing piece of evidence. This is the triumphant climax that we have come to know in trial films since this time. In addition to its self-referential gesture, making film, the story of film, around which the meaning of the story about law's relationship to truth is structured. How do we know truth? Because we can see it on film. Falsely Accused also participates in the trial film genre by featuring the film audience, we, the audience, as the jury. By showing the film of the crime in the court to solve the mystery and expose the true killer, the jury within the film, who's judging the evidence, and the film's audience, we already knew, we were told earlier that they didn't get the right person. We eventually share the same information about who committed the murder and then render this unanimous verdict of not guilty. And that releases the tension that the film created in its evidentiary dissonance. This, I suggest, is one of the origins of audience satisfaction that's in so many of trial films of similar ilk. And the reason, I think, that they have become such a popular genre over time. So here in 1907, the film camera is both evidence, and the film itself is a story of evidence, a way of knowing, a revelation. And it's also a story of how we come to know by showing a movie. Many, many trial films will contain similar features. So let's talk about moving on to First World War, and two film movements that developed in parallel in Germany and Russia. Those two film movements developed arguments about point of view. That is, we started seeing different kinds of narrators. One was an omniscient narrator that told the story like a godlike perspective, where the audience knows everything, for example, sort of documentary-like films. The other was the story of the first person, a film told in the first person, who becomes the subject of the film, and we become very intimate with that narrator. Now, you can imagine both of those films have different senses, so and problems. An omniscient narrator, like a documentary-like film, was Triumph of the Will in 1934, Leni Riefenstahl's famous documentary glorifying the Third Reich. That's the omniscient perspective, and you can see the deep focus here in the frame, giving a sense of all-knowing. Problems and excitement build in both of in that kind of narrator. The subjective narrator, like The Force of Evil in 1948, gives you the sense of anxiety and intimacy. You know this person very, very well, but you're not always sure, given the way the camera is working, to have that intimacy with you. Shots like this are very common in subjective point of view shots, where you're feeling both intrusive and maybe that you're involved in the story. The battle between omniscience versus subjective point of view is where we start seeing the seeds of, remember, we started in Germany and Russia, the American legal hero and legal subject. We go to 12 Angry Men. This is both omniscient, combining both the omniscient and the subjective point of view. This legal subject is going to stand apart from film story, independent and self-reliant, but is also going to be part of the legal story, central to its storytelling. Much like the idealized juror or legal hero whose independence from law is necessary for the righteous participation in it. So we may glorify the independence and self-reliance of the American hero, which is the first-person subject, but his perspective may not always be true, as we will learn. Indeed, in Primal Fear, for example, one of the classics from the last decade of the 20th century, we are duped at the end to have trusted this person for such a long time, and realize that he was withholding stuff from us. The first-person narrative, as you can imagine, problematizes the ability to know through sight based on who does the seeing and telling, whose view the audience is privy to. This is not unlike, in law, the credibility determinations made in trial regarding a witness testimony. So this all started, this idea of problematizing the first person. We've already problematized omniscience, right? So problematizing the first person began, it started in 1919 in German Expressionism with W.D. Griffith's Close-Up and Triumph of the Will. And it mirrors, it's where the film mirrors the psychological drama of the feelings of the single character. So the Cabinet of Dr. Caligari was the first one that all film students study, where you're for 2 hours, you're watching this film about this tragic but true story of the main character who turns out in the end to have been telling a deluded and paranoid fable from inside a mental institution. So I'm sure many of you have had the experience of you're watching this film and at the end there's this big reveal. You just didn't realize that everything you've been seeing has been sort of twisted in a way because you've only been privy to a certain perspective. That first-person narration problem began with this film. But slowly it evolved to films like Fritz Lang's M in 1931, which is the story of a serial killer whose perspective the audience is haunted by and privy to and intimate with, so much so that despite him being a despicable person, at the end when he cries out, "Who knows what it's like to be me?" the audience members actually feel this pull of empathy because we have been the ones that have been following him the whole time. So M is also a trial film, even though the only visible trial is a mob trial, mob justice. The legal system usurped by mobs, outlaws taking the reign of law, becomes a very familiar paradigm in American cinema in the coming decades. So let's just think all of this is happening without sound. The sound films, there was music and then there was subtitles, but the coincidence of speaking and what you saw didn't happen until 1927 with the jazz singer. So just think about all of this meaning circulating and cultural capital without audible words. That just proves the power of images. It proves the power of that pictures sufficed, pictures being the dominant mode even today. So when Fritz Lang, who made M, comes to the United States, he makes films like Fury. Anybody know this film, Fury? Yes, I love Spencer Tracy. He also makes films called Big Heat. Both of these films are law and justice kind of films, but between the two world wars, and maybe even to about the mid-50s, we have in what in the United States we call the film noir period. This is characterized by very dark, chiaroscuro kind of lighting, and it's all about the criminal underside of post-war glory of American life and institutions. Let me tell you about Fury, because if you haven't seen Fury, you need to see it. It stars Spencer Tracy, and he is this guy named Joe Wilson, who's wrongfully accused of kidnapping. And when he's detained in the jail, the mob outside, mob justice, sets fire to his jail cell. And we as the audience see him through the jail cell and we see the flames burning. His burning face and eventual confirmation of death is reproduced in newspapers and newsreels, film, in the film. And then we learn he's survived, but only we as the audience know. Film jury doesn't know. Nobody in the film knows that he survived. So here, the film within the film, the newspapers and the newsreel footage, the documentary-like evidence in the film that's eventually shown in court, the film of the fire burning him, it fails to reveal the truth that Joe survived, but instead perpetuates the lie of Joe's death. The film, pointing to itself in its moment of self-reflexivity, again, is revealing an untruth. And it's a clue to how the law in this film will fail to serve justice. So compare it to Falsely Accused, that first trial film I talked about, where the film revealed the truth of the murderer. Here, in the film noir period, in the 30s and 40s, film is telling a lie about the actual truth. Now, Joe is going to seek revenge for his near death, and instead of using the legal system to get revenge, he manipulates the district attorney and conspires with his brothers. You can see him looking pretty shady right there. Conspires with his brothers to assist in convicting the mob for his murder. Now, when the film jury is about to convict those in the crowd who set the fire, Joe dramatically enters the courtroom, another exciting climax, and halts the trial. So this film marks the beginning of 2 decades of legal films that criticize the law's capacity for justice. It also further evidences that liberal legal hero who, as he is positioned antithetical and outside to the law, Joe Wilson is an anti-hero, he nevertheless participates in the system eventually to right the institution that strayed from his goal. So these are sort of like legal cowboys, alienated from the formal legal system by choice or by force, who are eventually brought back or returned to see justice done. So while criticizing the system for failing its subjects, the legal hero adds strength to that system by showing how the truth and justice through law depends on participation by righteous individuals. So if you start thinking, films like this are plentiful. Well-known trial films include Young Mr. Lincoln from 1939 by John Ford, The Paradigm Case by Alfred Hitchcock by 1947. This is the time that classical Hollywood starts growing in momentum, and it becomes what turns out to be an antidote to film noir. And by that I mean we're going to get our memorable courtroom dramas and lawyers at this time that's going to comment on the system and that is evolving in the 40s, 50s, and 60s to accommodate development of our current understanding of civil liberties. So these are films that, in contrast to skepticism of Fury, for example, or M, are more hopeful. So Adam's Rib, for example. How many people have seen Adam's Rib? Right. This is a great film, also with Spencer Tracy, one of the only comedic. There aren't very many comedic trial films. 12 Angry Men, as I've already said, contributing to the every man's contribution to law's endeavor. Compulsion by Orson Welles. Orson Welles himself plays Clarence Darrow in the Loeb Leopold case. And in this film, he does something that's very unusual, which he breaks with the story and faces the film audience directly and delivers a 15-minute lecture on the injustice of the death penalty. Inherit the Wind from 1960, Stanley Kramer's rendition of the Scopes Monkey trial. Also Spencer Tracy. To Kill a Mockingbird, Gregory Peck from 1962, which brings to life Harper Lee's Atticus Finch and dramatizes the complicity of the American legal system with the personal and social tragedies of Jim Crow. So while Hollywood was creating and distributing these memorable stories and heroes of American justice and the pursuit of truth, in France there's this other more critical filmmaking going on, which is explaining how the mechanical means of photographic reproduction, that is, film itself, lulls us into this sense of objectivity. So concerned just how false objectivity would translate into narrative and politics, the study of film in the 1960s, and this should make sense given the politics of the time, began with the critical capacity to examine what we call the illusory coherence between the thing on film and the film itself. So this is going to sound like a repeat of the earlier days. How do we know how to judge what we're seeing? So film theorists wrote that the film is an instrument of ideology constituting its subject, whether it be the law or a kind of hero or community, through this false coherence of seeing things and the appearance of witnessing. So as we make a coherent narrative by understanding the story through that montage, we learn to desire certain kinds of heroes, desire certain kinds of endings. The film is cultivating expectations and desires. So think about how that works in contemporary film. Films like Erin Brockovich or North Country, both in this film tradition, echo in their stories the notion of the central independent individual. This is a myth, right? The central independent individual whose skepticism of law and marginalization is undone by the revelation in and through the legal process. How many trial films are combinations, for example, of docudramas like The Civil Action, based on a true story? Two genres that would best perpetuate an idealistic and perhaps naive view of the film's capacity and the law's ability to reveal truth. They are typical films in that they triumph that independent and determined, fair-minded citizen answering in the affirmative the question whether that lone legal hero, be it Spencer Tracy or John Travolta, who's devoted and idealistic, it could be Paul Newman, even, in The Verdict, or Tom Cruise in A Few Good Men, Denzel Washington in Philadelphia, George Clooney in Michael Clayton. These are legal heroes who prevail in a tainted legal system by making a difference through their determined and against all odds participation. Lawyers or protagonists in these films are everyday heroes. They're Davids in a Goliath system. The story is of access, of opportunity, determination, fairness no matter who you are or where you come from. It's an American story, but it's also an American ideal. It's not. My students go out into the world, that's not the world they encounter in trials or in investigations. So you should notice that most of these legal heroes are white men, except for Denzel here. Interestingly enough, something happens in 1990s. So this is how film starts constituting a new kind of community, and you're going to start seeing African American judges, both men and women, for example, and lawyers. So this is where is presenting a more hopeful, more inclusive future about the positions of power in the judicial system. By contrast, judges who are short-sighted or sort of crazy look like this, men carrying guns in a courtroom. This is Injustice for All. It's a wonderful film, if you haven't seen it. So many of these iconic trial films that I've put up, as I said, are true stories. True stories. Reversal of Fortune, Helter Skelter, The Accused, Cry in the Dark, In the Name of the Father. These are true stories making that ideology of the American independent-minded hero even more persuasive because they were based on true stories. And although many films are not self-reflective, that is, about film itself, it's not uncommon for the legal investigation in these films to be structured around a visual climax and revelation, uncovering a missing document, for example, a critical word, a missing identity. So the film's revelation of legal truth at the end revolves around an act of visual witnessing that facilitates justice. So other films that are based on true stories, Anatomy of Murder, based on a true story, Inherit the Wind, Judgment at Nuremberg, Young Mr. Lincoln was based on a true story, The Verdict, based on a true story here in Boston, People versus Larry Flint. This exemplifies through 100 years of cinema the central ties that bind film world making to legal world making. So from the beginning, when the actuality films where audience members ran from the theater, worried that the train would run them down, to this docudrama of civil action where viewing audiences are made to worry, really worry, also takes place in Boston, that the legal system is not sufficiently able to condemn polluters who cause illness and death, these films, all throughout this time, are playing on the question of how do we know what we know? And how do we decide we know what we do? And the law's relation to both of those things. Ultimately, they're about the difficulty and duty of judging as citizens. So the roots of early film are in these docudramas. They unify sight with knowledge, which is an issue in evidence and ways of knowing, and seeing as I see you and being seen as you see me, which is a question of subjectivity and the ability to judge each individual. And that, I would say, shows the roots of law in early film. Now, for those who watch television, I could tell a similar story, but I won't, about, at length anyway, about television. There are three main television genres about law. There's this Law and Order type police serial, which revolves around investigative teams that end with the revelation, usually guilt, after hard, courageous work and a lot of rule breaking. You notice how much people break rules in these TV shows. The most recent incarnation of this Law and Order kind of films is the series True Detective. How many people, has anybody in this room seen True Detective? It's incredible and heartbreaking. And it follows the same. These are cops who are incredibly compelling, who break every rule in the book at the end to get the most despicable serial killer you've ever met in your life. And you're like cheering them on, like do it, even though they're criminals themselves, these cops. How to Get Away with Murder, by Viola Davis, playing this. She's an edgy legal hero, legal law professor too, which is, my students turned me on to this one. She also breaks a lot of rules to get to the right result at the end. The second type of film, of legal television show, are the law firm kind of serials. So Damages, The Good Wife, Boston Legal, The Practice. And here, the story is really not about the law. It's about the teams, the group of people that work together. And here we're really judging the nature of our legal system by the characters of the people. Not whether they got the good guy or the bad guy, but about whether we like these people at all. That's what these TV shows are about. It's, again, about the subjectivity. The third kind of legal television genre is the reality television shows. People's Court, Judge Judy, the O.J. trial in the 90s and in 2016. Making of a Murder is the newest form of reality television. Anyone seen Making of a Murder? Oh, also very heartbreaking. This is a documentary. It's a documentary. It claims itself to be a documentary, which is hard to watch because it's hard to believe. The police are so corrupt in this documentary, and they're so flawed. And it's just heartbreaking. But we only really need to look around to recent events. And we are forced to ask, is reality on television? Or is television making reality? When courtroom television first began, we debated this so-called CSI effect. Our audiences so lulled by what they see that once we are participant in an actual jury trial, its process and procedure will be distorted by our expectations of what we should be seeing in that trial. Do people watch Judge Judy or Judge Ito and think that's what courts are like? Or when you turn on a camera in an interrogation room, for example, which we routinely do now, or you film a documentary about a murder, Thin Blue Line is another documentary about a murder investigation, are you not becoming part of the story that's being told? The Thin Blue Line was the impetus for the defendant in that case getting a new trial. The same has become true of Making of a Murder. The podcast sensation The Serial, so this is not visual now, this is just oral, Serial podcast, the most download podcast in history with I don't even know how many million listens, has become the reason for the central defendant in that case to get a new trial as well. These questions about the role of the camera in law are at the heart of the debate concerning cameras in the courtroom. Film and law collapse together as joined ways of telling the most definitive truth we can say about our world. Truth matters to law and to the confidence in our justice system, if not also to our democracy. But truth is not always easy to see. And it's rarely on film or television in any obvious way, as hard as we may look. What we see are ideals, are nightmares, little bits of things. The truth of our lives together is much more complex than a video image or a film story. Now, in the past few months and years, I'd say, we have St. Paul, the shooting of Philando Castile, we have Baton Rouge, we have Dallas, and it bears repeating that policing and legal decision-making is increasingly involving film, documentary-like film that competes for truth claims, my Facebook live feed versus the cop's dash cam recording, for example, competing for truth claims about brutality, justified use of force, racism. Bystanders of videos of police brutality don't answer the question of whether the police were motivated by racism and whether they had unjustified or justified fear for their lives. We bring that meaning to the films we watch. We come to these films of police brutality or of videotaped confessions, for example, with preconceived notions already about the justice and injustice of the event they portray. When I look at films of the killing of Philando Castile in Minnesota or Alton Sterling in Louisiana by police officers, I personally, as Jessica Silbey, I see inexcusable murder. That's what I see. But I know enough about US culture and lawyering and policing to know that not everyone sees what I see. Likewise, filmed interrogations, like this one, filmed confessions, body cams, dash cams, what story do they tell? We really should be asking whose story do they tell? And like most documentaries, they don't tell us what really happened, as if there's some singular, incontestable account. But as visual narratives, they're very good at persuading us of a point of view. And they can help contextualize truth claims. They can be part of a bigger story and a more complex one. So what we remember as film theorists and critics, as well as lawyers, that film is not the whole truth, but it participates in our culture as if it needs no explanation, which is a mistake. Film needs an explanation. Letting film speak for itself is leaving the world that the film creates in filmmakers' hands. So let me end with a very quick story about the Supreme Court. The Supreme Court that fell victim to the audience in 1894 in Paris. This is a story about Scott versus Harris from 2007, at the center of which was a video of a car chase taken from the dash cam of a police cruiser in pursuit of a subject. The video shows police officer racing down a dark, narrow road and deliberately ramming the suspect's car to end the chase. The suspect became a quadriplegic as a result of the crash. And the issue that was decided when he sued the police officers for unjustified use of force was whether or not they should have done what they did by causing the accident. You can imagine that the focal piece of evidence at trial and on appeal was the video. And at oral argument, Justices Breyer and Scalia were riveted by the video. They vocalized the power of film and their belief that the film captures reality, at least the most relevant part. So Justice Breyer says, his voice was raised. You can listen to these oral arguments if you like. "I see with my own eyes what happened. What am I supposed to do?" That is, that it was such a scary video chase that he had to ram the car. And Justice Scalia said, "It's the scariest chase I'd seen since the French Connection." So sure was Scalia of his and the court's majority interpretation of the video that justified the use of force because the suspect was perceived to have been going so fast on this narrow road that the cops had to stop him, otherwise somebody else would have gotten hurt, that they said far from being the cautious and controlled driver the lower court depicts, because the lower court, the trial court, said something different, what we see on the video more closely resembles a Hollywood car chase of the most frightening sort, placing police officers and innocent bystanders alike at great risk of serious injury. And then they put the video, they put a link in the opinion to the video, which is up on the Supreme Court's website, and says, look at it yourself. We're happy to allow the videotape to speak for itself. So, there was one dissenter in Scott versus Harris, and that was Justice Stevens, who was the oldest judge on the bench at the time, and the one, as it turns out, the most savvy to technology and film. What he says is, "I can only conclude that my colleagues were unduly frightened by 2 or 3 images on the tape that looked like bursts of lightning or explosions, but were in fact merely the headlights of vehicles zooming by in the opposite lane. Had they learned to drive," and he like I did, "when most high-speed driving took place on 2-lane roads rather than on superhighways, when split-second judgments about the risk of passing a slowpoke in the face of oncoming traffic were routine, they might well have reacted to the videotape more dispassionately." So what does Justice Stevens do? He contextualizes the video evidence in light of his experience of the world. He does what many film and cultural critics do, and he asks how the film's portrayal of the event is being shaped and coaxed by particular experiences and point of view, whether it's a close-up, like a dash cam, a bird's eye view on the dashboard that can feel very scary, or what if it had been an omniscient point of view of the chase scene? That would have felt very different, I think, to these justices. He does not disregard the film as worthy of consideration, but he understands its undue power and its undue relevance. And he just says, let's put it online with all the other evidence in the case. So he did not fall victim to those original audience members, but 8 justices of the Supreme Court did. So film very persuasively constructs a world for us. It's compelling, it's lovable, it's scary, but like all other forms of communication, be it oral testimony, documentary evidence, Twitter, Snapchat, Facebook, whatever kind of evidence that we're going to put in there, all of it must be interpreted and scrutinized and evaluated and cross-examined. That's what I teach my students to do, is to cross-examine film. So the history of law in film and television is idealized for sure as heroes. We can easily see corruption on film, quick procedural fixes, but that's not the world we live in. Film tells potent stories and may foster civic engagement or social change, but we need much more than these beloved characters or shocking images to achieve equal justice under the law. Film gets the story going, it plants seeds, it suggests hopeful outcomes, but it's really up to the audience members and the collective work of communities committed to peace and human flourishing for all to make sure that the story that the film begins will end well for all of us. Thank you.
We have some time for questions.
Or suggestions for films I should watch. Yeah.
You mentioned the film Judgment of Nuremberg and Castle, the 1961 Academy Award-winning film. Is that the only international trial film?
No, there are many international trial films. So Name of the Father was one I put up there, which is also an international trial film that takes place in Ireland. There are many. I focus mostly on American trial films because I'm concerned with how it constitutes American law, because that's what I teach, and how images of American law are exported out to the rest of the world. But Judgment in Nuremberg is an interesting film because you have an American judge bringing American values to post-war Germany, which makes it a very interesting story about the contest between certain values in a courtroom. Any other questions? Films? Yeah.
Do you think jurors are really up for analyzing and understanding this interrogation of what is real and what is not? Because a jury is somewhat of a cross-section of society with different levels of education, and your approach seems to be sort of postmodern literature in which everything is up for grabs. Nothing is definitively, quote, real.
Yeah.
And yet the jurors are supposed to find what really happened.
For sure, for sure. So I have a lot of faith in jurors, actually. When I was a trial attorney and when I worked in the federal courts for a judge, regularly would advise juries, I have a lot of faith in them. And what I think, so there are moments when you're working with juries that are very sad, where they realize that this is hard, that preponderance of the evidence, I need to find 51% that they are negligent. Like, what does that mean? And so the education of a juror is that it's not always easy to figure out what the right answer is. So I think being humble in the face of that ambiguity actually makes jurors better at what they do, and they learn that pretty quickly. But I'll tell you, I actually also think that most of us are film critics at heart. We watch TV shows or films, and we ask critical questions regularly. Did they really look like that? Or why did it tell that story? Or I don't like the ending. And we do our own research. So one of the questions that I often ask my students, and when I was a practicing lawyer, I would challenge the jurors, is bring that criticism here. Just don't accept everything at face value. And it's not that hard to just undo a story that is one-sided. So let me just give you an example of one case. So when you have a filmed confession that's filmed straight on, so the camera's looking at me and I'm confessing to a crime, It is perceived by most people to be a voluntary confession because I fill the screen. If the angle of the camera is canted like that and you only see the side of my face, or if the interrogator is in the frame with me and I confess, about 50–60% of people will not be sure whether that same confession is voluntarily rendered. So all that does is tell you that camera angle will change how I perceive the exact same words. And so then the jurors have to say, I need to evaluate voluntariness, which is what we did in that case, based on all the evidence, not just the film evidence. I want to know, was he shackled underneath the table where the film didn't show? I want to know how long he was in the interrogation room before the camera went on. I want to know how hot it was. I want to know when he asked for an attorney. I want to know how old he was, whether he had been detained before. There are all sorts of things that make it a much more complicated analysis, but which are relevant to the question of voluntariness. And so it's not, I think it should be hard to make these determinations. And I think as long as you wrestle with the difficulty of it, you're doing your job. And I have to say, I've never, I mean, there have been plenty of times where I think juries made mistakes, but never when this kind of critical eye is brought to what looks like uncontroversial evidence. So I have a lot of faith in them. Has anybody here been on a jury? Yeah. Yeah. Other questions? Yeah.
Well, people are really interested in this because now there's even a channel, investigative discovery,
Yeah.
that would make you think that you're going to be murdered at any point in your life because it's murder 24/7.
Yeah.
If you watch that channel.
Yeah.
I have to admit to being a homicide hunter.
Yeah, homicide hunter, right.
Although I know it's not real, but it's interesting.
Yeah.
What are your favorite police or legal shows? What are the things you might watch at the end of a time? Or maybe you don't.
Too much information. So I was a big fan of The Good Wife most recently because I like strong female characters because there are so few of them that are not just wearing short skirts. And so and the thing about The Good Wife is they based a lot of their legal disputes on real cases that I could then, because I'm that kind of geek, go and like figure out what did they change about the story to tell a better story in an hour. And I'm interested. I mean, lawyers are storytellers. Teachers, frankly, have to be very good entertainers. And I spend a lot of time thinking, how do you condense a lot of information into a short amount of time, keep the essential stuff that needs to be told, and keep people entertained and paying attention. So I think The Good Wife did that very well. And I like that story a lot. I'm also a sucker for A Few Good Men. I watch that on a regular basis. I don't know why. I just like that film. But I'm always looking for new films. I had a hard time watching Making of a Murderer because it upset me so much. And that's because, so just about popular culture and images live in our brain. The neuroscience of it lives in our brain differently than words do. I mean, you must all feel this way. Like you have visual memories that are stronger than word memories. Okay, so when you watch a movie of something happening or you see a picture of something happening, it occupies the part of your brain that is the same part of your brain that would create a memory as if you had lived that thing. So if you watched a film about someone swimming in the Black Sea, and then there's another person who actually swam in the Black Sea, that memory lives in the same part of your brain. So there is something very powerful about the fact that we become colonized in some ways by these images. And so learning the way we learn new languages, the way we learn how to hear things differently, depending on who's speaking to us, like when my mother says something to me versus my daughter says something to me, it could be the exact same thing, but I will hear them differently, right? When we train ourselves to hear different things, we can also train ourselves to understand film differently than actual lived experiences. But I think that in our culture today, we're just bombarded all the time, and we're tired, and we watch TV uncritically, and that's fine. I think it's the lawyer's job when somebody's life is at stake or somebody's livelihood to just make sure that we push back on that a little bit more in that dispute process. Yeah, and then, yeah.
I grew up in the Perry Mason era, and that was the first thing that put going to law school in my head. And eventually I did go, and I remember I had a professor that was dealing with workers' compensation. And I'm sure you know that when you have an arbitration, you get lists of lawyers' names, and you get to cross off the ones you don't want to hear your evidence. And he told us, much to my chagrin, that he made sure that he gave each side, he bound for each side so that they were, in the future, they wouldn't mark them off the list. So sometimes he would actually find for the side that he really didn't believe in, but because he hadn't given them a case before, so he would keep being called upon to deal with judgment applications.
Right. So this is a story about the self-interestedness of arbitrators. Right. Yeah. I'm sorry to hear that story, although it doesn't surprise me. Getting rid of personal conflict and self-interest in law is a very, very difficult thing. And that, sympathetically, I would say most of us feel like we can be objective when we're asked to be objective. Like, I can be objective. But it's the reason the rules exist is because we make mistakes like that all the time, and somebody needs to enforce them. It's a very hard one. I mean, in constitutional law, we're talking about, for example, whether President-elect Trump has real conflicts of interest because of the businesses that he owns. That's a hard question. I mean, I don't think it's hard under the Constitution, but conflict rules are they can be very ambiguous. And what we tend to say in law is we should err on the side of no perception of conflict, so that everyone can be assured that even if that the perception, and this is what this talk was about, the perception could create the conflict and the civil unrest in the first place, even if there is no actual conflict in reality. So judges recuse themselves on a regular basis, even if there's a perception of conflict, and that really that's a belt and suspenders kind of approach, and that's really what the rule should be. Yeah.
When I was in law school, the professor staged a fake fight in the classroom. Then he dramatically dismissed them from the room, and he said, "All right, everyone else, write a paragraph what you saw, heard, and felt."
Yeah.
Then he began to read 6 different versions.
Yeah.
To tell you the limitations of eyewitness, and he says what happens in person can also happen in film.
Yeah.
Because of the angle, the distance, the color, the clearness.
Yeah.
You're introduced to your own prejudices.
Yeah, it is such an important questions about implicit bias. We don't think we're biased, but then we're biased, and then we take tests and we realize I did prefer these kind of person over this, or just not seeing certain things. There's a famous film that people used to show about these kids playing basketball, and you're watching them play basketball, and then in the back, you don't see it unless somebody tells you there's a person in a gorilla suit walking around. And that's the same kind of thing, right? So we know this about ourselves. And so one of the questions that we're regularly fighting with is how do we incorporate that knowledge of the partiality of our own point of view in these important processes like trials or dispute resolution where people's life and livelihood and property are at stake. And so most of the time we say in law that the process is what should protect the truth. That we can't ever know what happened. There are very few people who will ever know what really, really happened. What we can say we did is we preserved the process of fairness. And so this talk and my work on film is really about not letting film dominate the evidence the way it did in the Supreme Court, is that we need to value eyewitnesses, we need to value documentary evidence, we need to value multiple points of view on the event. So one of the things, for example, with the filmed confessions and interrogations that I had mentioned before is once it was shown that the angle determines whether the confession is perceived as voluntary, police offices all over the country started implementing multiple angles for the videotapes. And that confessions that were only filmed straight on like that were going to be presumptively inadmissible. There had to be an image of the interrogator and the defendant in the film. So that's a way to counteract implicit bias and things. But the more we know about it, the more we can implement these changes. But of course, the more we're critical, the better it will be as well. Any other? Thank you. Thank you for inviting me. Let's see. All right.
Well, I'd just like to say we're certainly appreciative of your presentation. And I think, for example, the concept of cross-examining the film is a powerful idea that we can all take away with us. On the other hand, I am very, very, very tiny disappointed you didn't mention Judge Roy Bean or my cousin Vinny. Okay. But maybe that can be for next time. In any case, I'd like to present you with this small token of our appreciation. Thank you very much. Just a quick reminder that this is the last presentation here for this semester. I want to give a few kudos since I have the opportunity and it seems an appropriate time. First of all, I'd like to thank the Northeastern's Office of Alumni Relations and Samantha Boland and her staff. I'd also like to thank all the committee members who contribute ideas in helping with the presentations. And finally, I want to thank all you folks for coming to our presentations, for your attention and interest that you show. And a special thanks to all of those of you who have filled out our little survey forms with your feelings about the presentations and some ideas for future presentations. So, big hand for you. Okay, the committee will be having a meeting with the Office of Alumni Relations in mid-January to go through each and every one of the surveys you've filled out and the ideas you've presented. So look for us to give you a mailing the end of February or early March. Okay, thanks, and enjoy the rest of the day. If we still have some pastry left, please help yourself. We won't tell your primary care.